ಬಂದವರುಗಳಿಗೆ ಐಲುವಿನ ಪದಾಧಿಕಾರಿಗಳು ಮತ್ತು ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ಸದಸ್ಯರುಗಳು ಎಲ್ಲರಿಗೂ ವಂದನೆಗಳು, ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಇವತ್ತಿನ ಉಪನ್ಯಾಸ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರೈಬ್ಯುನಲ್ಸ್ ಜುರಿಸ್ಡಿಕ್ಷನ್ ಅಂಡ್ ಪ್ರಾಕ್ಟೀಸ್ ಪ್ರೊಸೀಜರ್ಸ್ ಅಂತ ಹೇಳಿ ಈ ವಿಚಾರವಾಗಿ ತುಂಬಾ ಹಿರಿಯರು, ನಮಗೆಲ್ಲ ಒಂದು ಮಾರ್ಗದರ್ಶಕರು, ಸುಮಾರು 40 ವರ್ಷಕ್ಕಿಂತ ಹೆಚ್ಚಿನ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಗಳಲ್ಲಿ ಅನುಭವ ಇರುವಂತ ವಕೀಲರಾಗಿರುವಂತವರು ಶ್ರೀಯುತ ಟಿ ನಾರಾಯಣಸ್ವಾಮಿ. ಇವರು ಇತ್ತೀಚೆಗೆ ಕರ್ನಾಟಕ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರೈಬ್ಯುನಲ್ ಅದರ ಜುಡಿಷಿಯಲ್ ಮೆಂಬರ್ ಆಗಿ ಸುಮಾರು ಒಂದು 2-3 ತಿಂಗಳ ಹಿಂದೆ ನಿವೃತ್ತರಾಗಿದ್ದಾರೆ. ಸುಮಾರು 8 ವರ್ಷಕ್ಕಿಂತ ಹೆಚ್ಚಾಗಿ KATL ಜುಡಿಷಿಯಲ್ ಮೆಂಬರ್ ಆಗಿದ್ದು ತುಂಬಾ ಜನ ನೌಕರರಿಗೆ ಅವರು ಸಾಕಷ್ಟು ರಿಲೀಫ್ ಅನ್ನ ಕೊಟ್ಟಿರುವಂತಹ ಒಂದು ಮಹಾಶ್ರಯರು. ಅವರು ನಮ್ಮ ಜೊತೆ ಇವತ್ತು ನಮಗೆಲ್ಲ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರೈಬ್ಯುನಲ್ ಅದರ ಜುರಿಸ್ಡಿಕ್ಷನ್ ಮತ್ತು ಪ್ರೊಸೀಜರ್ ಗಳನ್ನ ಅವರ ಬಾಯಿಂದ ಹೇಳುವಂತದ್ದು ನಮಗೆಲ್ಲ ಒಂದು ಹೆಮ್ಮೆ ಕೊಡುವಂತ ವಿಚಾರ. ಸೊ ವಿ ವುಡ್ ಲೈಕ್ ಟು ಲರ್ನ್ ಎ ಲಾಟ್, ಅಂಡ್ ಅಪಾರ್ಟ್ ಫ್ರಮ್ ಹಿಸ್ ಅಕಾಡೆಮಿಕ್ ಕ್ರೆಡೆನ್ಶಿಯಲ್ಸ್, ಎ ನೋಬಲ್ ಪರ್ಸನ್, ವೆರಿ ಹಂಬಲ್ ಪರ್ಸನ್. He has been a guide, a mentor in all respects to all of us. ಅವರು ಕೂಡ ಐಲುವಿನ ಇದೇನೋ ಇದಾಗ್ತಾ ಇದೆ ದಿಲೀಪ್, ಸಮಥಿಂಗ್ ಇಸ್ ಹ್ಯಾಪನಿಂಗ್ ಹಿಯರ್. ಅದರಿಂದ ಐ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಟೇಕ್ ಮಚ್ ಆಫ್ ಯುವರ್ ಆಲ್ ಟೈಮ್. ನಾವು ದಯವಿಟ್ಟು ಶ್ರೀ ನಾರಾಯಣಸ್ವಾಮಿ ಸರ್ ಅವರಿಗೆ ಈ ಒಂದು ವಿಚಾರ ಬಗ್ಗೆ ತಮ್ಮ ಉಪನ್ಯಾಸವನ್ನು ಪ್ರಾರಂಭ ಮಾಡೋಕ್ಕೆ ಕೋರಿಕೊಳ್ಳುತ್ತಿದ್ದೇನೆ. ಎಲ್ಲರೂ ದಯವಿಟ್ಟು ಈ ವಿಚಾರವನ್ನು ಕೇಳಿ. ಇದು ತುಂಬಾ ಜನ ಈ ಪಾಠವನ್ನು ಹೇಳ್ಕೊಡೋದಿಲ್ಲ. Many of the lecturers will not even touch about this subject. It's really a great occasion. We request all of you to please utilize this opportunity and learn a lot about administrative tribunals. So ದಯವಿಟ್ಟು ಶುರು ಮಾಡಬಹುದು ಸರ್, ಪ್ಲೀಸ್. ಯಾವ್ದೋ ಪ್ರಶ್ನೆಗಳಿದ್ರೆ ಕೊನೆಯಲ್ಲಿ ಪ್ರಶ್ನೆಗಳನ್ನ ಕೇಳಿ. ದಯವಿಟ್ಟು ಎಲ್ಲರೂ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡು ವಿಡಿಯೋ ಮತ್ತು ಆಡಿಯೋ ಎರಡು ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. 45 ಗಂಟೆ ಉಪನ್ಯಾಸ ಆದ ಮೇಲೆ ಪ್ರಶ್ನೆಗಳನ್ನ ಕೇಳಿ. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಎಲ್ಲ ಹಿರಿಯ ಮತ್ತು ಕಿರಿಯ ವಕೀಲರ ಮಿತ್ರರೇ ಅಂಡ್ AILU ಆಫೀಸ್ ಬೇರರ್ಸ್, ಸ್ಟೂಡೆಂಟ್ಸ್ and other persons who are in the lecture class today. All India Lawyers Union started in the year 1982. Though it is started in 1982, we all joined after few years. As far as Karnataka is concerned, most probably that may not be a subject here. I thought it is relevant to speak something about AILU, Karnataka, how it is grown, what they are doing it. The purpose of this class required to be conducted by the AILU as a part of their constitution, that is AILU constitution. In the year 1982, in view of the circumstances prevailing at relevant point of time, Honorable Justice Krishnaiyer, D.A. Desai, and the then Chief Minister of West Bengal, Jyoti Basu, and others thought of forming an association which can take and safeguard the constitution and the principle of the constitution. And they convened the meeting at Delhi, in which was attended from Karnataka by Justice V. Gopalagowda, Justice Nagmohan Das, K.R. Venkatesh Gowda, and S. Shankarappa. Those are all the initial members of Karnataka state. They joined the meeting. Thereafter, they decided to form an association or union called All India Lawyers Union. Subsequently, in Karnataka also, Karnataka State Youth Committee is started, that is running. I wanted to bring a few provisions of the All India Lawyers Union. The slogan of All India Lawyers Union is secularism, democracy, and socialism. If you see the preamble of the Constitution, it is the same as that of the AILU. That AILU members are required to follow the AILU Constitution. One of the object of Constitution AILU is to continue, apart from educating the masses, to continue education. I think it is a part of that object. This class is arranged. The AILU for many years, for last many years, that too specifically after COVID has erupted the society, started educating through video conferencing. Even now they are running it. As a part of continuing education, today class is arranged. I was invited to speak on the subject. Earlier, I was also a member of this organization, worked in different capacity. For last few years, I was out of that organization and also the profession for having taken the responsibility of other job as a judicial member in Karnataka Administrative Tribunal. The subject assigned for today's class is administrative tribunals, jurisdiction, and procedure. For the purpose of ascertaining the object of formation for this class, we require to know the object for which administrative tribunals have been constituted. Immediately after Constitution is adopted and following it, there are certain provisions which are safeguarding the interest of the government servants to protect their interest and also their rights. The cases were filed before courts, in constitutional courts and also in various other courts. You are also aware that a government servant can approach the High Court under 226, Supreme Court under 32. Even earlier there was a provision under Section 9. Some of the government employees also used to approach the civil court seeking declaration. When cases are flooded before the courts with regard to their service conditions, in the year 1969, a committee was set up by the central government under the chairmanship of Justice Saha of the Supreme Court to make waste means to effective, expeditious and satisfactory disposal of the matters relating to service disputes. As the employees, rather we can say government servants, are facing great hardship for having the pendency of matters before the high courts under 226 and also before the various courts for the long delay in disposal of the matters. Even government was also facing much problem in not disposing of those cases in early manner. You know that in some of the cases where the matter required to be decided immediately within short time, if it is not decided, then it will affect the government, employee, and adversaries, that is, other parties who involved in that litigation. The recommendation made by that Saha committee is to form form tribunals for the speedy disposal of the cases relating to government servants. Subsequently, the Law Commission, headed by will give you the name, headed by Singh as constituted. There was a recommendation for the purpose of establishment of administrative tribunals and other tribunals. In the meanwhile, in the year 1974, in the case of Ramachandra Sarkar Devodar versus State of Maharashtra, it is reported in 1974 SC 259. Court has found that there is a delay in disposal of the service matters and the pendency before various high courts, Supreme Court, and other civil jurisdiction of the courts. Observe in that matter, it is observed that we find in the course of our judicial experience, and we noticed this fact with some apprehension that the members of public service is alarming large number resort to legal remedies in course of law for agitating their grievances in regard to the service matter. This phenomenon is a simple symptom of sense of injustice and subversive of the undivided and devoted attention to the official duties, which is so essential for attention of the official duties, which is so essential for efficient and dynamic functioning of the government. With this, a recommendation is observation made for speedy disposal. Then a supervising committee has been formed, and the recommendation was for forming administrative tribunals to resolve the service disputes. Even after that, there was no initiation on the part of the central government in that regard. Thereafter, on certain agitations and also the pressure brought on the government, a 42nd amendment was brought to the Constitution by incorporating 323A for the purpose of formation of the administrative tribunals. Even the formation, the amendment was brought by a 42nd amendment. There was no progress in that. Subsequently, in the year 1980, the Honorable Apex Court once again take note of the large pendency of cases. In the case of Kamal Kanti Datta and others versus Union of India, reported in NAR 1980 SC 2056, and observe with regard to the constitution of tribunals for adjudication of service jurisprudence. In view of such observations made therein, and also on considering the various other aspects, the government enacted Administrative Tribunal Act by Act number 13 of 1985 by issuing notification on 27 to 1985. The said act come into force on 1/7/1985. By way of the constitutional amendment, the provision is created. Provision is made for creation of administrative tribunals to decide the service related issues in respect of government servants and other corporation servants who fall within the civil servants of the state, and also for other persons. On enacting the Administrative Tribunal Act, the central government issued notification dated 28/5/1985, constituting Central Administrative Tribunal initially with the effect from 2nd October 1985. Good. After 1 year, on the request made by Karnataka state government, a notification dated 3/10/1986 came to be issued, establishing Karnataka Administrative Tribunal with the effect from 6th October 1986. Subsequently, the name of the Karnataka Administrative Tribunal is altered or amended as Karnataka State Administrative Tribunal. Good. In view of enactment of Administrative Tribunal, as far as central government is concerned, central government servants are concerned, 19 central administrative benches has been established, which is located in different parts. The principal bench is located at Delhi. Other benches are Ahmedabad, Allahabad, Bangalore, Chandigarh, Chennai, Cuttack, Ernakulam, Guwahati, Hyderabad, Jabalpur, Jaipur, Jammu, Jodhpur, Kolkata, Lucknow, Mumbai, Srinagar, and Patna. Apart from these 19, another 17 circulation benches, central administrative tribunal circulation benches are available. That central administrative tribunal functioning full-fledged. As far as state administrative tribunals are concerned, initially 9 state tribunals had been established. That is Karnataka, Tamil Nadu, Kerala, Andhra Pradesh, Orissa, Maharashtra, West Bengal, Himachal Pradesh, Madhya Pradesh. After lapse of certain period, or depending upon the workability, or depending upon the government's requirement, Tamil Nadu, Orissa, recently AP, Madhya Pradesh, and Himachal Pradesh have abolished the state tribunals. At present, Karnataka, Kerala, West Bengal, and Maharashtra having the state administrative tribunals. This is with regard to constitution and the establishment of administrative tribunals in central as well as state. Now after considering this, we will proceed to look into the provisions of Administrative Tribunal Act. Sir, ಕೇಳುತ್ತಾ ಸರ್ ಕರೆಕ್ಟ್ ಆಗಿ?
Yes, sir. Yes, sir.
ಕೇಳ್ತಿದೆ
Yes,
ಸರ್.
sir.
There is no
Correct ಆಗಿ-
problem.
No problem at all.
Yes.
Audible.
ಸರ್ ಒಂದು ರಿಕ್ವೆಸ್ಟ್
Audible, sir.
ಸರ್, ಒಂದು
ಹೇಳಿ
ಆಡಿಬಲ್
ಸರ್.
ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಸರ್. ತುಂಬಾ ಜನ ವಿದ್ಯಾರ್ಥಿಗಳು ಸ್ವಲ್ಪ ಕನ್ನಡದಲ್ಲೂ ಕೇಳ್ತಾರೆ, ದಯವಿಟ್ಟು ಸ್ವಲ್ಪ ಕನ್ನಡದಲ್ಲೂ ಸ್ವಲ್ಪ ಮಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ಅನುಕೂಲ ಆಗಬಹುದು ಸರ್.
ಆಯ್ತು ಸರ್, ಮಧ್ಯ ಮಧ್ಯೆ ಸೇರಿಸೋಣ.
ಸ್ವಲ್ಪ ಸೇರಿಸ್ಬೇಕು.
ಯಾಕಂದ್ರೆ ಕನ್ನಡದಲ್ಲಿ ಲೆಕ್ಚರ್ ಕೊಡುವಂತದ್ದು ಸ್ವಲ್ಪ ಕಷ್ಟದ ಬದುಕೆ ನನ್ನ ಪಾಲಿಗೆ ಮಾತ್ರ.
ಹೌದು ಸರ್, ನಿಜ ಸರ್.
ಹ್ಮ್.
ಅಬ್ಸಲ್ಯೂಟ್ಲಿ.
ಈಗಾಗಲೇ ಹೇಳಿರುವಂತೆ ಆಡಳಿತಾತ್ಮಕ ನ್ಯಾಯಮಂಡಳಿ 1985ರಲ್ಲಿ ಪ್ರಾರಂಭವಾಗಿ ಅದರಲ್ಲಿ 2 ಪಾರ್ಟ್ ಏನು ಅಂತಂದ್ರೆ ಕೇಂದ್ರ ನೌಕರರಿಗೆ, ಸರ್ಕಾರಿ ನೌಕರರಿಗಾಗಿ ಕೇಂದ್ರೀಯ ಆಡಳಿತಾತ್ಮಕ ನ್ಯಾಯಮಂಡಳಿ, ರಾಜ್ಯ ಸರ್ಕಾರದಲ್ಲಿ ನೌಕರರಾಗಿರುವಂತವರಿಗೆ ರಾಜ್ಯ ಆಡಳಿತ ನ್ಯಾಯಮಂಡಳಿಗಳಾಗಿ ಇರೋ ಪಾರ್ಟ್ ಅನ್ನು ಇದುವರೆಗೆ ಮುಗಿಸಿದೀವಿ. ಈಗ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರೈಬ್ಯುನಲ್ ಆಕ್ಟ್ 1985 ಕೆಲವು ಪ್ರಾವಿಷನ್ಸ್ ಅನ್ನ ನೋಡ್ಲಿಕ್ಕೆ ಹೊರಡೋಣ ಅಂತ ಅನಿಸ್ತದೆ. ಇಟ್ ಈಸ್ ನೆಸರಿ ಅಂತ. ಈ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರೈಬ್ಯುನಲ್ ಆಕ್ಟ್ ಈಸ್ ಅಪ್ಲಿಕಬಲ್ to the members to whom Administrative Tribunal Act is applicable anta we will require to be see. Before that, we require to consider to whom it is not applied. Any member of naval, military, or air forces, or of any other armed forces of the Union. Now, for these persons, an army army tribunal is constituted recently. Recently means till last 4 or 5 years back. Others, any officer or servant, Supreme Court or any High Court or court subordinate thereto, for whom this Administrative Tribunal Act is not applicable. It's also not applicable to secretariat staff of either House of Parliament or to the secretariat staff of any of the state legislature or houses of and union territory legislature offices. As they are governed by separate statutory rules, they fall within the purview of high courts to get their grievances. Next, we require to see, apart from all other things, it is not necessary the definition of appropriate government, bench, central administrative tribunal, what we have sent. The tribunal service, we will see the service matter. This is defined at section 3Q of Administrative Tribunal Act. As per that definition, all matters relating to the conditions of his services or of any local or authority within territory of India or under the control of Government of India, or as the case may be, or any corporation or society owned or controlled by the government as respects, in respect of remuneration, including the allowances, pension and other retirement benefits of those employees who worked in those government and organizations, with regard to tenure, including the confirmation, seniority, promotion, reversion, premature retirement, and superannuation, leave, and any kind, disciplinary matter, any other matter whatsoever, that means allied matters which are required to be considered by the persons, having the grievances regarding those, and also with regard to service rules governing the conditions of service of those persons, can approach if the persons or service conditions are related to the civil service and servants of central government, to the central administrative tribunal. If they comes under the state government, they are required to approach the administrative tribunal. There are another aspect required to be considered, is that there are certain other persons who are not eligible to be approach the tribunal, though they are working in the government or government organization. That is census employees, that is casual employees who are not civil servants. They are not entitled to approach the tribunal, either government or central administrative tribunal or state administrative tribunal. Further, it is also necessary to consider the provisions with regard to I feel that appointment and other aspects relating to the judicial and administrative members are not necessary for us to consider while dealing with the procedural aspects, all these aspects. That is entirely different, which can be considered separately. Section 14 of the Administrative Tribunal Act deals with jurisdiction, power, and authority of the central tribunal. Rule 15, section 15 is relating to power and authority of the state administrative tribunal. Except these two provisions, what are all mentioned therein are the same. Initially, we consider the Rule 14 to say that it also indicates that central administrative tribunal required to exercise the powers from the appointed day for adjudication, powers and authority exercisable immediately from the date of it is coming to force, relating to recruitment of central government employees and a matter concerning to recruitment to any all India service or to any civil services of union or a civil post under the union or to a post connected with defense or in defense service, being in either case a post filling the by a civil servant, civilian. That means in defense and also in army, other than armed forces, other civilians are also working. They require to approach the administrative tribunals for the purpose of their grievance relating to recruitment or other service conditions, which includes seniority, pay, promotion, and other allied issues. Further, another one is that all service matter concerning to a member of any All India service or a person not being a member of All India service or a person referred to under state service is required to go to the All India service. They are also with regard to All India service issue, they are required to approach the Central Administrative Tribunal. That means any issue relating to the central civil services or concerning to central civil services or All India civil services, the government servants concerning to those issues required to approach the Central Administrative Tribunals. Full stop. Here, and now we will come to little later. Come to section 15 is also similar to that of the section 14. The all government servants relating government servants or civil servants working in the state with regard to their service conditions and also the recruitment and a matter concerning to recruitment to any civil services of state or any civil post under the state, they are required to approach the administrative tribunal of the state. As far as this state is concerned, Karnataka State Administrative Tribunal. They also required to, with regard to service matter concerning to a person, who are the civilians, they wanted to come to the civil services of the state or to ventilate their grievances. In respect of that, they required to approach the administrative tribunal. And also with regard to other issues relating to local authorities and other authorities, which is called as under Article 12, for within the definition of Article 12, they also are required to be 12, come within, approach the administrative tribunal, provided a notification is issued by the government, bringing those institutions within the purview of the administrative tribunal. As far as Karnataka state is concerned, there was no notification issued so far bringing any of the authorities within the purview of administrative tribunal. Rather, we require to consider with reference to Karnataka state administrative tribunal is concerned, jurisdiction only in respect of civil servants or government servants who are all working in the Karnataka state government alone, not with regard to authorities. Authorities, namely the municipalities, municipal corporations, the other authorities, other corporation, KEP, and other allied corporations, they are not brought within the purview of the administrative tribunal. On the other hand, their grievances required to be ventilated before the High Court under 226 or any other avocation provided to them under their special statutes. Here, I will come back to section 14 to say a few words, much more words. As I already said, in respect of Karnataka, no other authorities brought within the purview of state administrative tribunal, whereas the central administrative, almost all organizations, that is societies, which is discharging the functions of the government for the purpose of, they were bifurcated from the central government and formed the separate organization for their own convenience. There, such as earlier BSNL was the part of the central government. A corporation is created by forming a different corporation. That corporation is also subsequently brought within the purview of the central administrative tribunal by issuing a notification. Likewise, many organizations, that is authorities, which is registered under Society Registration Act or under a corporation, which is a government corporation, they were brought within the purview of central government. They are part of central government, fall within the purview of central administrative tribunal. After ascertaining the jurisdiction of the tribunals, who can approach the tribunal? Now we proceed further with reference to the constitution of benches, which is composition of the tribunal and benches thereof. Why I have considered earlier with regard to jurisdiction and other aspects is, immediately we, as a lawyer or a litigant, who know that whether I can approach the administrative tribunal or elsewhere my relief is there, we require to think. Then it comes to how many tribunals are there, what type of tribunals are there, we require to consider. Or this composition with regard to the tribunal consists of chairman, judicial members, and administrative members. Earlier, the post of vice chairman was incorporated. Subsequently, that is removed in the year 2007. It seems, I feel it is in the 2007. As far as central government is concerned, though as already stated, there are 19 tribunals are established in different parts. Here, the principal bench is situated at Delhi, where chairman and other benches were there. Benches means benches of that principal bench. As far as other benches are concerned, the senior member of the bench will be the concerned member who look after the affairs of the benches. The bench consists of judicial member and administrative member. The chairman has got power under the Administrative Tribunal Act to constitute a bench consisting of judicial member alone or the administrative member alone. As far as Karnataka State Administrative Tribunal is concerned, there are judgments to the effect that the administrative member has no authority to decide independently by sitting as a member, heading the bench, decide the issue relating to the service disputes relating to the employees. In Central Administrative Tribunal, in many occasions we have seen that even administrative members are also sit and the function as a members in even in Bangalore bench also, and sometimes you have seen the administrative member sitting singly and proceedings have been conducted. As far as state administrative tribunal is concerned, it is not so. It appears in central administrative tribunal, it's a practice, therefore they are deciding. It's also there is also a provision that certain disputes relating to the service should be decided by the bench consisting of the judicial member and administrative member. Bench means the bench consisting of judicial member and administrative member. ಆ ಕೆಲವು ಡಿಸ್ಪ್ಯೂಟ್ಗಳನ್ನ ಸಿಂಗಲ್ ಆಗಿ ಜುಡಿಷಿಯಲ್ ಮೆಂಬರ್ ಒಬ್ಬರೇ ತೀರ್ಮಾನ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವು ಯಾವಂತಂತಂದ್ರೆ, ವೆನ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ವ್ಯಾಲಿಡಿಟಿ ಆಫ್ ಎ ರೂಲ್ಸ್, that is service rules, is questioned, same required to be decided by a bench consisting of the judicial member and administrative member. And where strict, serious interpretation of rule or constitutional provisions are involved, then bench required to be hear and decide the issue. On the other hand, it is open for the chairman to constitute single member bench consisting of judicial member or administrative member to transact the business of the tribunals. As far as Karnataka is concerned, for last many years, the single members, that is judicial members, sit singly and decide the issues. They accept the constitutional validity of the rules. All other issues, except there are some seniority issues which involves serious interpretation of the provisions relating to seniority of concerned employees, concerned government servants. Even while deciding the issues by the bench, that is judicial member or administrative member, those members can, while hearing, can decide themselves and state that these matters required to be decided by the bench in view of seriousness involved in those cases. At that time, the chairman will constitute the bench consisting of two members, that is judicial and administrative members. There is one more provision is available with regard to one more issue one should know with reference to Rule 5. The chairman is always a judicial member. So far, as far as Karnataka state and also so far what I have seen in Central Administrative Tribunal, in sometimes chairman has got dual role to play. A chairman sitting with another judicial member, sitting with another administrative member, he will act as a judicial member and decide the cases. In some occasions, there are certain occasions where the chairman sits with another judicial member. He can be considered as an administrative member. Those cases can be decided, which is clear from section 5.6 of 5.8 of 6 and 8 of Administrative Tribunal Act, which provides that whenever an occasion arises, the chairman can sit along with another judicial member, decide the issue that has to be construed as a bench for the purpose of deciding the issue. Such a issue recently arisen before the Karnataka State Administrative Tribunal, wherein while deciding when a judgment rendered by a bench consisting of honorable chairman and another bench at Belagaum is cited before a bench consisting of judicial member and another administrative member. At that time, without accepting that as a precedent or a binding judgment, the judicial member has, administrative member has rendered separate judgment by indicating that is not a judgment at all. Upon considering the same, when the matter was referred to the another judicial member as a third bench as required under the Administrative Tribunal Act, then a judgment has come referring to all those provisions and also various judgments rendered by Apex Court and also the Honorable High Court, various High Courts held that the chairman can sit along with judicial member. At that time, he will act as a administrative member. That judgment is also a judgment or order. It is binding on another bench of a judge, tribunal like that. Therefore, to know that is so important for lawyers to assert such a fact before when such a situation is arisen. Since the such issue arisen before the Karnataka State Administrative Tribunal itself, and the same came to be brought to notice of myself when I was sitting at Kalaburgi and Bangalore. Therefore, it's an important. Therefore, I brought that to your notice. Even I can say the single member who decided that issue by me alone. If necessary, I can pass on that case number to the host. He can pass on that number and that to all others. They can look into that decision for their benefit. After considering the composition of the benches, now we will proceed to other aspects, that is, what is the procedure to be followed under the Act to approach the tribunal. Initially, we consider Section 19, which deals with applications to the tribunal. That is Chapter 4, and under the heading of procedure. It provides that when a government servant or a aggrieved person having a grievance relating to the service or affected his service conditions, he can file an application in a prescribed format provided under the rules relating to the rules framed under the Act before the tribunal by incorporating his grievance with the prior. The tribunal will entertain the same initially, order notice, thereafter hear the other side, and on receiving the documents, by affording opportunity to all those persons who are adversaries and decide the issues. Therefore, those decisions will be called as orders, and those decisions will be rendered instantly, that is within a short period, unless the other side is dragged on. With my experience, at present, as far as Central Administrative Tribunal Bangalore bench and also by the Karnataka Administrative Tribunal, no case is pending beyond 6 months or 1 year. It serves the purpose or object for which it is those tribunals are established. As far as Central Administrative Tribunals are concerned, It appears at Delhi, principal bench at Delhi, where large number of cases are there. Cases are pending. And at Ahmedabad bench, there is a large number of pendency. As far as other benches are concerned, there is no such pendency. Therefore, the government servants can get speedy relief before the tribunal. Most probably, many of my friends who appeared before the Karnataka Administrative Tribunal, even most probably they might have appeared today, and now they are before this class, and they know that cases will be decided within 3 or 4 weeks, as there was no much problem for deciding those disputes. And it is so simple. The court will consider the issue at a stretch and decide the cases instantly, and rendering justice to the party. Result is the other aspect. Decision, they will get the decision immediately. Another aspect required to be considered with reference to the Administrative Tribunal Act is that the tribunals are not governed by principles of Evidence Act or strict rules of Evidence Act or other rigid formula. It's governed by principles of natural justice that we can find at section 22 of Administrative Tribunal Act. It starts with procedure and powers of Administrative Tribunal. With the leave of all you people, I may be permitted to read the provision. A tribunal shall not be bound by procedure laid down in Code of Civil Procedure, but shall be guided by principles of natural justice and subject to the other provisions of this Act and any rules made by central government. The tribunal shall have power to regulate its own procedure, including the fixing the places and time of its inquiry and deciding whether sit in public or in private. Next, the tribunal shall decide every application made to it as expeditiously as possible, and ordinarily every application shall be decided on a perusal of the documents and written representations, and after hearing such oral arguments as may be advanced. That I have indicated to you earlier with reference to administrative tribunals. On filing application under section 19 of Administrative Tribunal Act, with all your documents, order on issuing notice, they will call for objections from the adversaries and hear those persons and deciding the issue. There is no issue with regarding recording of evidence as required under Evidence Act or Civil Procedure Code and decided by the civil courts, and also hearing elaborately to any other unnecessary issues, they will decide. I have also indicated to you just now the cases now decided by Karnataka Administrative Tribunal and Bangalore bench of this tribunal, Central Administrative Tribunal. It will that life of an application most probably not more than 6 months, as indicated by the provisions. They are adherent to the provisions and deciding the grievances made by the government civil servants or aspirants for civil services immediately. Next, 22(3) says that tribunal shall have, for the purpose of discharging its functions under this Act, the same power ought to be vested in civil court under the Code of Civil Procedure in respect of the matters summoning and enforcing the attendance of any person and examining him on oath. To my knowledge goes. So far, summoning those persons, examining those persons is not arisen as far as Karnataka Administrative Tribunal is concerned. Sometimes tribunal, for having not responding to the query made by the tribunal, are summoned some officials and getting clarifications without recording any evidence. They have decided the cases and requiring to discover and production of those documents. It is well-known principle. Once there are certain documents which is hidden and a reply is filed, the applicant or the party who approaches needs to know what are all those documents. They can file an application under these provisions and then get summon those documents. If documents are not produced, then draw adverse inference as provided under the Evidence Act, and the court can decide it. And also receive the evidence on affidavits. According to me, there was no occasion for the tribunal to reach that level, that stage. Even for issuing commissions for examination of witness or documents, also not arisen. And there is a provision provided under the section 22. Review the decisions of the administrative tribunal. 22. 2F provides for reviewing its decision. It is well-known principle that if the tribunal finds that the decision rendered by the tribunal on brought to its notice, it can review suo motu or on an application if it is brought to the notice that there is omission on the part of the tribunal in not considering the relevant material as required under Order 41 Rule 27 CPC, the court can review the decision. There is also a provision as that of Order 9 Rule 13 in CPC to recall the order passed by the tribunal in dismissing the application for default on the part of a council or a party, or it has got power to set aside the order of dismissal of any representation for default. That is what I have stated. This is for default made by the. These are all the relevant provisions. We can utilize the benefit of the provisions of Civil Procedure Code for deciding the issues by the tribunal while adjudicating the cases relating to civil servants also. Even in the absence of that, according to me, principles of natural justice or justice required such an approach by a judge to decide all those matters. For example, a judge missed a point or a law enunciated by the apex court while deciding a case, and adverse order is passed. If it is brought to the notice while filing an application seeking and bringing to the notice, it is magnanimity on the part of that judge or a judicial member or administrative, whatever may be those members of the tribunal, to look into it and recall and render justice to the party. That is called substantial justice for having approached the courts. Even in high courts, many times what I observed is that judges would say that if any fault on their part, that is suo motu, they will recall and they render justice to the issue. Further, one more provision we require to bring it to your concern is tribunal has got power under section 24 to grant interim relief. It is not wise to grant in all the cases if prima facie made out as that of in other cases which is considered by the High Court that grave injustice is caused, if not interim order is not granted, all those aspects that you know very well, the court can grant interim order safeguarding the interest of a party or immediate damage to those persons who approach the courts. It's a well settled principle that in recruitment process, there are certain judgments. Stalling recruitment is not permissible. Stalling promotions is not permissible. There are a large number of cases of that nature is there. But an individual who approached the court and the damage, immediate damage he will place is not compensatable by way of the cannot be restored. It's not permissible to restore or compensated. Then at that situation, interim relief can be granted, which is also provided under section 24 of Administrative Tribunal Act. Even otherwise, according to me, while deciding an issue, even in the absence of a provision, it is inherent on the part of a court to grant interim relief to prevent injustice to a party. I distinctly remember, because for last 6 years I forgotten those SC/ST Act, Karnataka State PTCL Act. When there is a judgment, if a person filed an application for restoration of land, that is decided, then appeal is filed. There is no provision for seeking granting interim order. Under the circumstances, somewhere I remember 1992 or so, division bench judgment is there. Muni Lakshmamma versus State of Karnataka, it may be. The Honorable High Court has held that the grant of interim order of that nature is inherent on the authority or appellate authority like that and decided. There, that's not the case here. Section 24 is taking care of all those aspects and decide the issue. The section 24 is relating to power to the chairman to transfer cases from one bench to another bench. It is there. It is required to be considered with reference to the Central Administrative Tribunal. Different benches are there. Most probably, I said 19 benches are there. If any bench is disabled to decide or something is there, the chairman has got administrative power under section 25, recall a case from a bench and place it before some other bench. As far as Karnataka state is concerned, there are 3 benches. That is in Bangalore, principal bench, Belagavi and Kalburgi. Belagavi, Kalburgi, single bench, one court, courts are functioning. In Bangalore, 3 benches are there. If one bench is disabled, the chairman can withdraw and transfer or place the said dispute before some other benches. It is within the purview, which fall within section 25. Even otherwise, rule 4, allocation of business, it is provided. Another provision we require to consider with reference to implementations or obeying implementation of the decisions. Section 17 provides for power to punish for contempt. The tribunal, on deciding the issue relating to a case, the direction will be issued to comply the same, or party who got the benefit will comply required to get benefit is the government or the authorities or a particular department is not ready to obey that order, they require the same can be complaint invoking rules section 17 of Contempt of Courts Act. The power under the section 17 is as that of Contempt of Courts Act, and the power vested with the High Court under 215 of Constitution of India. Therefore, there is a provision also provided for implementation of the orders. Even there is a provision provided under section 27, the execution orders of the tribunal. For the purpose of this section 27, there should be a rule. There should be a rule. The tribunal should frame a rule for the purpose of execution of earlier Karnataka Administrative Tribunal framed the rules called execution rules. It seems the same is resigned subsequently. Yes, resigned subsequently. In Central Administrative Tribunal, there is no such rules framed. They are utilizing section 17 of Administrative Tribunal Act on complaining, for initiating contempt proceedings and get it implementing the orders passed by the respective tribunals. Another aspect required to be highlighted with regard to procedural aspect is that when an application required to be filed under section 90, same has to be filed within limitation prescribed under section 20 of Administrative Tribunal Act. And also there is a provision provided under section 20 on exhausting the alternative remedy provided under the service rules. They are required to approach the tribunal. In the absence of, the tribunal will not entertain the grievance of a person, an aggrieved person who can approach, who approaches with a grievance. The section 20 is of two parts. One is that an occurrence of a cause of action within 1 year, a party required to approach. If a remedy of appeal is provided, then on submitting the appeal or a representation to the concerned authority, if it is statutory, then after waiting for 6 months, they can approach the tribunal. If he or she approach within 6 months, that cannot be entertainable. But there are certain situations where immediately on submitting the representations, the party is not in a position to wait even for a day. In those circumstances, that remedy of an appeal is not an efficacious. It's a formally, it is a representative is submitted. They can approach tribunal in any number of times, entertained. For example, a suspension under KCS CCA rules or under CCS CCA rules. A provision is provided under KCS CCA rules. Rule 18 provides an appeal remedy. Invariably, the party approaches without exhausting the appeal remedy, indicating that by quoting certain aspects that a order is illegal. in most times, the tribunal is not insisted in those circumstances regarding 18 complying with 18 of KCSCCA rules, for the reason that suspension, which will come into force immediately if a statutory violation is indicated, court can consider immediately and grant the relief, or we can relegate the party with certain direction to approach the tribunal, authority, or a same authority or an appellate authority by ventilating those facts. Thereafter, he can approach the tribunal. That is one aspect. Even in the case of dismissal or discharge or in termination cases, the appeal is provided under section 18 of KCSCCA rules. That is mandatory. Even some cases, tribunal without insisting for appeal entertained, indicating that if it is violation of statutory provision or constitutional provisions or principles of natural justice, directly you can approach without the appeal, without filing the appeal before the competent authority or an appellate authority. Example is that if a termination is passed without holding inquiry for misconduct, then there is no question of filing appeal before appellate authority, as it directly indicates that it is in violation of Article 311 2B of the Constitution. In that, without holding an inquiry, the dismissing an employee or terminating an employee for misconduct is not permissible. Under such situation, the government servant can directly approach the administrative tribunal. Alternative remedy is not a bar in such circumstances. In that regard, large number of cases or case laws are available. Even in the cases of dismissal, after holding an inquiry, if inquiry itself vitiates without following Rule 11 of KCSCCA rules, then there is no fun in approaching the appellate authority, ventilating that. If that appellate authority keep that file for a months together, then deciding and remanding the matter to the authority to comply with. In that aspect, the courts have held that in such situation, alternative remedy of appeal is not an efficacious. It is a discretionary relief the court can grant even under Article 226. That is akin as under 19 of Administrative Tribunal Act. This is the situation. Even in compulsory retirement or in any number of such situations, it is there. Therefore, the section 20, where it provides that required to be considered, where it is mandatory, it is required. Now, it is not always under certain circumstances. Now I covered section 20 and 21 together. Therefore, I concluded myself with reference to the procedural aspects, the process administrative tribunal decides the issues. Then I take leave of you. Any questions with this? And I request if any questions are there, you can ask me directly. As far as possible, I can indicate here only, or I can intimate to the concerned authority. Before concluding, I require to say two more aspects I forgotten to, though I noted, I forgotten. Immediately on, after enacting the Administrative Tribunal Act, at that time, there was no provision provided to approach the High Court. There is a bar for the government servants or civil servants to approach any other court, including the Supreme Court directly. Section 28 prohibits and debars entertaining the same. At that moment, some SPs, in some cases, matter went up to Supreme Court. Ultimately, Honorable Supreme Court in SP Sampath Kumar versus Union of India was pending. The central union government amended the provisions with regard to Supreme Court. As far as High Court are concerned, 226 is barred. And when matter was pending, the Supreme Court in L. Chandrakumar versus Union of India, year 1997 SC 1150, held that it is not permissible for a statute to take away the judicial review under Article 226 and strike down the provision to the extent that the Constitution of Administrative Tribunal under 4.2 and is valid. Therefore, it acts as a court of first instance. The civil servants or grievances relating to the civil services required to approach the administrative tribunal, including challenging the validity of the rules, initially to be tried by administrative tribunal. Then any order passed by the tribunal required to be questioned before, maybe questioned before the High Court, and same required to be decided by division bench of High Courts. Thereby, the now against the order passed, the government or government servants filing writ petitions, and same will filed before, posted before division bench. This is important aspect. I forgotten to indicate that. Even in respect of, I already indicated, the certain employees who are, civil servants or officials working in various organizations, few can approach the government, tribunal, remain they required to. One such example is that in municipalities, the persons who were under the care of municipal administrative service alone can approach the administrative tribunal. All others, that is municipal employees, required to approach administrative tribunal for want of a notification issued by the government conferring power on the Administrative Tribunal Act to consider and adjudicate the issues relating to those employees. As far as central government is concerned, almost all organizations, I think though nobody is left so far to consider to approach the administrative tribunals. With this, I conclude my presentations and leave it. I hand over to the organizer to get, if there's any questions are there, to forward to me with that request. Thank you for patient hearing, and thank you one and all.
ತುಂಬಾ ಧನ್ಯವಾದಗಳು ಸರ್. ತುಂಬಾ ಇನ್ಫ್ಯಾಕ್ಟ್ ನಮ್ಗೂ ಕೂಡ ಸಾಕಷ್ಟು ವಿಚಾರಗಳು ತಿಳ್ಕೊಳ್ಬೇಕಾಗಿ ಬಂತು. ಎಸ್ಪೆಷಲಿ
ಇಲ್ಲ, ನಾನು ನೋಟ್ ನಿಮ್ಗೆ ಹೇಳ್ಬೇಕು ಅಂದ್ರೆ ನಾನು ನೋಟ್ ಮಾಡ್ಕೊಂಡಿರೋದ್ರಲ್ಲಿ 20% ನಿಮಗೆ ಹೇಳಲಿಲ್ಲ. ಯಾಕೆ ಅಂತಂತಂದ್ರೆ
ವೆರಿ ವೆರಿ
ಇದನ್ನ ಹೇಳಲಿಕ್ಕೆ ಹೊರಟಾಗ ಅನದರ್ 1 hour ಆದ್ರೂ ಬೇಕಿತ್ತು.
ಬೇಕು ಸರ್, ಬೇಕು ಸರ್, ಬೇಕು ಸರ್, ಬೇಕು ಸರ್. ಸರ್, ಸಾಮಾನ್ಯವಾಗಿ ನನಗೆ ಕಳಿಸಿರುವ ಮೆಸೇಜ್ಗಳಲ್ಲಿ ಬಂದಿರುವಂತ ಪ್ರಶ್ನೆಗಳೇನಂತ, ದೇರ್ ಇಸ್ ಲಾಟ್ ಆಫ್ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಅಥವಾ ಕನ್ಫ್ಯೂಷನ್ಸ್. ಆರ್ಟಿಕಲ್ 12 ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಲ್ಲಿ ಹಲವಾರು ಪಬ್ಲಿಕ್ ಸೆಕ್ಟರ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೂಡ ಇದರಲ್ಲಿ ಬರ್ತದೆ. ಪಬ್ಲಿಕ್ ಅಂಡರ್ಟೇಕಿಂಗ್ಸ್ ಇರಬಹುದು, ಕಾರ್ಪೊರೇಷನ್ಸ್ ಇರಬಹುದು. ಈ ತರ ಸಂಸ್ಥೆಗಳಲ್ಲಿ ಯಾವ್ದಾದ್ರೆ ವಿಚಾರಗಳು ರಿಲೇಟೆಡ್ ಟು ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಗಳು ಬರುವಾಗ, ಎಸ್ಪೆಷಲಿ ನಾಟ್ ದ ವರ್ಕ್ಮನ್ ಕ್ಯಾಟಗರಿ, ಐ ಆಮ್ ಟಾಕಿಂಗ್ ಬಟ್ ಅದರ್ ದನ್ ವರ್ಕ್ಮನ್ ಕ್ಯಾಟಗರಿ ಬರುವಾಗ, ಅವರುಗಳು ವೆದರ್ ದೇ ಮೇ ಹ್ಯಾವ್ ಟು ಅಪ್ರೋಚ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರಿಬ್ಯುನಲ್ ಹೋಗ್ಬೇಕಾಗಿ ಬರ್ತದ, ಅಥವಾ ದೇ ಮೇ ಹ್ಯಾವ್ ಟು ಅಪ್ರೋಚ್ ದಿ ಹೈಕೋರ್ಟ್ ಅಂಡರ್ ಆರ್ಟಿಕಲ್ 226 ಆಫ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಪ್ರಶ್ನೆ ಬರುತ್ತೆ.
ಇದಕ್ಕೆ ಹೇಳೋದೇನು ಅಂತಂತಂದ್ರೆ, ನಾನು ಸ್ಟಾರ್ಟ್ ಮಾಡಿ ಸೆಂಟ್ರಲ್ ಗೌರ್ಮೆಂಟ್ ಅಂಡ್ ಸ್ಟೇಟ್ ಗೌರ್ಮೆಂಟ್ ವಿಷಯದಲ್ಲಿ ಹೇಳಿದಿರ್ಬೇಕು ಅಂತಂದಾಗ, ಸೆಂಟ್ರಲ್ ಗೌರ್ಮೆಂಟ್ ಇದರಲ್ಲಿ ವೇರಿಯಸ್ ಆರ್ಗನೈಸೇಷನ್ಸ್ ಇದೆ. ಎಲ್ಲದನ್ನೂ ಸಹ ಸೊಸೈಟೀಸು, ಕಾರ್ಪೊರೇಷನ್ಸ್ ಇದೆಲ್ಲ ಮಾಡಿ ಗೌರ್ಮೆಂಟ್ ಫಂಕ್ಷನ್ಸ್ ಅನ್ನೆಲ್ಲ ಅದಕ್ಕೆ ಇಂಟ್ರೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಯು ನೋ ದಟ್ BSNL, ಟೆಲಿಕಾಂ, ಆಲ್ ಅದರ್ ಆರ್ಗನೈಸೇಷನ್ಸ್ ಅವ್ರದ್ದೆಲ್ಲಾನು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ನೋಟಿಫಿಕೇಶನ್ಸ್, ಇನಿಷಿಯಲಿ ದೇರ್ ವಾಸ್ ಎ ಡಿಸ್ಪ್ಯೂಟ್, ನೋಟಿಫಿಕೇಶನ್ಸ್ ಕೊಟ್ಟು ಅವರು ಸೆಂಟ್ರಲ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರೈಬ್ಯುನಲ್ ನ ಅಪ್ರೋಚ್ ಆಗಬೇಕು ಅಂತಂದು ಜೂರಿಸ್ಡಿಕ್ಷನ್ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ. As far as state is concerned, I have stated none of the persons, organization, that is including municipal corporations, KSRTC, other organizations, ಯಾವುದನ್ನು jurisdiction administrative tribunal ಗೆ ಬರೋ ತರ ನೋಟಿಫಿಕೇಶನ್ ಇಲ್ಲ. On the other hand, that's why I said while explaining with reference to the municipalities ಅಲ್ಲಿ 2 cadre of employees are there: municipal employees and the municipal administrative service employees, officers. 365 of KMC Act provides that, and Karnataka Municipal Administrative Rules provides certain municipal employees required to be get promotion to the municipal administrative service. ಅವರು ಆ ಗ್ರಿವೆನ್ಸ್ ಇದಕ್ಕೋಸ್ಕರ KIT ಬರ್ಬೋದು. ಇಲ್ಲ, ಆ ಮುನ್ಸಿಪಲ್ ಎಂಪ್ಲಾಯೀಸ್ ಎಲ್ಲೇ ಕೆಲಸ ಮಾಡ್ತಿದ್ರು ಸಹ ಅವರು ಮುನ್ಸಿಪಲ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಸರ್ವಿಸ್ ಆಗಿತ್ತು ಅಂತಂದ್ರೆ ಬರ್ಲಿಕ್ಕಾಗತ್ತೆ, ಇಲ್ಲ ಬರ್ಲಿಕ್ಕಾಗಲ್ಲ ಅಂತ ನಾನು ಹೇಳಿದೆ. Another one more thing I require to be indicated: the government servants or civil servants who are deputed or transferred or posted to the various organizations such as municipal corporations or municipalities or various other organizations fall within controlled by the government. With regard to their grievances, those civil servants required to approach the administrative tribunal alone, not the High Court. This, it seems, it clarifies the question posed to you and indicated to you and posed to me. This is sufficient.
Sir, what about the banking sector? Banking sectorಗಳಲ್ಲಿ there are some state related banking sector. ಉದಾಹರಣೆಗೆ ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಫೈನಾನ್ಷಿಯಲ್ ಕಾರ್ಪೊರೇಷನ್ಸ್ ಗಳಿರುತ್ತೆ. ಇವರುಗಳಿರುವಂತಹ ವಿಚಾರ
ಅವರು ಹೈಕೋರ್ಟ್ ಬರಬೇಕು.
ವಾಟ್ ಇಸ್ ದಿ ವೆದರ್ ದಿಸ್ ಇಸ್ ಎಕ್ಸ್ಕ್ಲೂಡೆಡ್ ಫ್ರಮ್ ದಿ ಪರ್ವಿ ಆಫ್ KIT ನಾ?
ಅಲ್ಲ, ಅದಕ್ಕೆ ನೋಡಿ ಇಲ್ಲಿ ಹೇಳ್ತಾರಲ್ಲ, ಯು ಕಮ್ ಟು 14 or 15,
ಸೆಕ್ಷನ್ 14 and 15 ಆಫ್
15 ಅಂತಾದ್ರೆ ಸ್ಟೇಟ್ ಟ್ರೈಬ್ಯುನಲ್, 14 ಆದ್ರೆ ಸೆಂಟ್ರಲ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರೈಬ್ಯುನಲ್. ವಿ ವಿಲ್ ರೀಡ್ 15 ಯಾಕಂದ್ರೆ ವಿ ಆರ್ ಇನ್ ಕರ್ನಾಟಕ. ದೇರ್ ಫೋರ್ ಸೆಂಟ್ರಲ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರೈಬ್ಯುನಲ್, ಮೆನಿ ಕಾರ್ಪೊರೇಷನ್ಸ್ ಅಂಡ್ ಆರ್ಗನೈಸೇಷನ್ಸ್ have come. We will read 15 starts with jurisdiction, power, authority of the administrative tribunals. Save otherwise expressly provided in this act, administrative tribunal for the state shall exercise on and from appointed day all the jurisdiction, power and authority exercisable immediately before that day by all courts except the Supreme Court in relation to recruitment and matter concerning to recruitment to any civil services of the state or to any civil post under the state. B. All service matter concerning a person not being a person referred to clause C of this subsection or a member person or civilian referred to in the clause B of the subsection 1 of section 14 appointed to any civil service of the state or any civil post under the state and pertaining to the service of such person in connection with the affairs of the state or of any local or other authority under the control of the state government or of any corporation or society owned or controlled by the state government. That's what I indicated to you just now to the question. If government servant is posted to a corporation or a society owned by the government or controlled by the government or any other authority controlled by the government, then he can approach administrative tribunal with regard to his grievance. Next, the provision is all service matter pertaining to the services in connection with the affairs of the state concerning a person appointed to any service or post referred to in B, being a person whose services have been placed by any such local or other authority or corporation or society or other body as is controlled or owned by the state government at the disposal of the state government for such appointment, even for the appointment to the such authorities, if government servants are posted, they can approach the administrative tribunal. Next, 15.2. State government may, by notification, apply with the effect from such date as may be specified in the notification the provisions of subsection 3 to local or other authorities and corporation or societies controlled or owned by the state government. It indicates that unless and until such notification is not issued, then tribunal will not get any jurisdiction to entertain those persons' grievances, provided if the state government considered it expedient to do so for the purpose of facilitating the transaction of schemes enshrined by this act. Different dates they may issue all those things. It's of no problem. Unless and until notification is issued in respect of KSFC or financial Karnataka Food and Civil Supplies Corporation or financial corporation or any other authority, the tribunal will not get jurisdiction. That the government required to think over and issue the notification in that regard. I was also informed that there was a move earlier that was dropped. Even from the beginning, the advocates who are practicing in administrative tribunal are making effort before the government to get the concern of the government to issue notification to strengthen the administrative tribunal or to conferring jurisdiction on in respect of those persons, so that the tribunal will get more cases, then high court burden will be reduced to some extent in that regard. There was no such move by the government. It seems they are not inclined to issue such a notifications and not issue. It's very difficult to say that they are not inclined but they have not thought of issuing the notifications. I think this.
ಹೌದು ಸರ್, ಧನ್ಯವಾದ. ಸೊ ಇನ್ನೊಂದು ಪ್ರಶ್ನೆಗಳು ಬಂದಿದೆ. ಯಾವುದಂತ ಹೇಳಿದ್ರೆ, ವೆದರ್ ದ ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್ ಕ್ಯಾನ್ ಅಪ್ರೋಚ್ ಹೈಕೋರ್ಟ್ ಕೋರ್ಟ್ ಡೈರೆಕ್ಟ್ಲಿ ವಿತೌಟ್ ಅಪ್ರೋಚಿಂಗ್ ದ ಟ್ರೈಬ್ಯುನಲ್. ಇಫ್ ಸೊ, ಕ್ಯಾನ್ ಹೈಕೋರ್ಟ್ ಎಂಟರ್ಟೈನ್ ದಿಸ್ ಸಚ್ ಟೈಪ್ ಆಫ್ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಪ್ರಶ್ನೆಗಳು ಬಂತು.
ಹೇಳಿ ಇನ್ನೊಂದ್ಸಾರಿ ಹೇಳಿ.
ಹೇಳಿ ಸರ್.
ಸ್ವಲ್ಪ ಅಲ್ಲ, ಅಲ್ಲಿ ಯಾರು ಕೇಳ್ತಾ ಇದಾರೋ ಅವ್ರನ್ನ ಕೇಳಲಿ ಕ್ವಶನ್.
ಇಲ್ಲ, ಅಲ್ಲಿ
ಕರೆಕ್ಟ್ ಸರ್.
ಇಲ್ಲ, ಕರೆಕ್ಟ್. ಇಲ್ಲಿ ಆತ ಪ್ರಶ್ನೆಗಳ ಹಾಕಿ ಚಾಟ್ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
ಕರೆಕ್ಟ್. ಆ ಪ್ರಶ್ನೆ ಯಾರು ಕೇಳಿದಾರೋ ಅವ್ರನ್ನೇ ಕೇಳಂತ ಹೇಳು.
ನೋ ಪ್ರಾಬ್ಲಮ್.
ಆಕ್ಚುಲಿ ನಾವು ಮಾಡಬಾರ್ದು ಅದು
ಸರ್. ಇಲ್ಲಿ ಸರ್ ಇವಾಗ ಬಂದಿದೆ, ಕೇಳಿದೀವಿ.
ಅವರು
ಈಗ ನಿಮಗೆ
ಡೌಟ್ ಅವ್ರು
ಕ್ವಶನ್ ಈಸ್ ದಟ್ whether government servant or civil servant can directly approach the high court ಅಂತ.
ಹೌದು ಸರ್, ಹೌದು ಸರ್,
ಕರೆಕ್ಟ್ ಅಲ್ವಾ?
ಹೌದು ಸರ್.
In any number of cases it is decided, especially in L. Chandrakumar's case, paragraph number 1993 specifically says that and states that the government servants required to approach the administrative tribunal as at the first case of first instance.
Allah, in case they do not approach the tribunal which has been formed to dispose of the government servants grievances, and if they directly go to the high court, whether it is
question clarity illa sir.
Allah, ಈಗ ಸರ್ಕಾರಿ ನೌಕರರು ಅವರ ಸಮಸ್ಯೆಗಳನ್ನ ಪರಿಹರಿಸಿಕೊಳ್ಳೋದಿಕ್ಕೆ ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಟ್ರಿಬ್ಯುನಲ್ ಇದೆ. ಅದನ್ನು ಬಿಟ್ಟು ನೇರವಾಗಿ ಅವರ ಸಮಸ್ಯೆಗಳ ಪರಿಹಾರಕ್ಕೆ ಹೈಕೋರ್ಟ್ಗೆ ಹೋಗಬಹುದಾ?
ಇಲ್ಲ.
ಒಂದು ವೇಳೆ ಹೋದರೆ ಹೈಕೋರ್ಟ್ ಅಂತಹ ಕೇಸುಗಳನ್ನು ಎಂಟರ್ಟೈನ್ ಮಾಡಬಹುದಾ?
ಮಾಡೋದಿಲ್ಲ. Section 28 of Administrative Tribunal bars even Supreme Court, while conferring jurisdiction on challenge before jurisdiction on the High Court to entertain the challenge with regard to the orders of the tribunal, clearly said in no case, even to challenge the rules, government servants required to approach the administrative tribunal as a court of first instance ಅಂತ ಹೇಳಿದ್ದಾರೆ. Para 93, 1997 Supreme Court, page 1150, para 93. I am damn sure with reference to that para.
ಸರಿ ಸ್ವಾಮಿ, ಸರಿ ಸ್ವಾಮಿ.
ಯಾಕೆ ಡ್ಯಾಮ್ ಶೂರ್ ಅಂತ ಹೇಳಿದೆ ಅಂತಂದ್ರೆ, ಲಾಯರ್ ಆಗಿದ್ದಾಗ ಬಹಳ ಸಾರಿ ಅದನ್ನು ಉಪಯೋಗಿಸ್ಕೊಂಡಿದ್ದೀವಿ. ನಂತರ ಕೆಲವರು ಬರದೇ ಇದ್ದವರು, ಟ್ರೈಬ್ಯುನಲ್ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಬರದೇ ಇದ್ದವರು ಬಂದಾಗ ಇವರು ಮಾತ್ರ ಬರಬಹುದು ನೋಡಿ, ಇವರು ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್ಸ್ ಅಲ್ಲಿ ಹೋಗ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ ಅಂತ ಹೇಳಲಿಕ್ಕೆ ಕೂಡ ಅದನ್ನು ಬಳಸ್ಕೊಂಡಿದೆ ಅಂತ ಹೇಳಲಿಕ್ಕೆ. ಎನಿ ಅದರ್ ಕ್ವಶನ್ಸ್ ಸರ್?
ಸರ್, ಅವರು ಕೆಲವರು ಕೇಳಿದ್ದಾರೆ. ಅವರೇ ಒಂದು ವೇಳೆ ಅವರೇ ಇದ್ರೆ ಅವರಿಗೆ ಪ್ರಶ್ನೆ ಕೇಳಬಹುದು.
ಹೇಳಿ, ನನಗೇನಿದೇನಿಲ್ಲ.
ಅದು ಕೃಷ್ಣಪ್ಪನವರು ಇನ್ನೂ ಪ್ರಶ್ನೆ ಕೇಳಿದ್ದಾರೆ. ಇನ್ ಕೇಸ್ ಆಫ್ ಡಿಸ್ಪ್ಯೂಟ್ ರಿಗಾರ್ಡಿಂಗ್ ಕಮ್ಯುನಿಕೇಶನ್ ಕ್ಯಾನ್ ವಿ ಅಪ್ರೋಚ್ ಹೈಕೋರ್ಟ್ ವಿತೌಟ್ ಅಪ್ರೋಚಿಂಗ್? ಅದಕ್ಕೆ ನಾವು ಆನ್ಸರ್ ಮಾಡಿ
ಆಯ್ತಲ್ಲ,
ಅದು ಮಾಡಿದ್ದೀವಿ. ಇನ್ನೊಂದು ಈ ಪ್ರಶ್ನೆಗಳು ಬಂದಿದೆ ಸರ್. ಯಾವುದಂತ ಹೇಳಿದ್ರೆ, there is a question, I don't know whether if the person is available, he himself can directly see that clarification. Pension claims and gratuity disputes be agitated before but ಕೇಳಿದ್ದಾನೆ administrative tribunal.
It's also service dispute. State government employee concerned, DCRG is the gratuity. Pension is a pension. It is fall within the purview of the administrative tribunal, KCSR. ಯಾಕಂದ್ರೆ ಪೆನ್ಷನ್ ಅಂದ್ರೆ ಏನು, ಗ್ರಾಜ್ಯುಟಿ ಅಂದ್ರೆ ಏನು ಅಂತಂದು ಹೇಳ್ಬೇಕು ಅಂತಂದ್ರೆ, ಸರ್ವಿಸ್ ಲಾ ಅನ್ನು ಡೀಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೊರಟಾಗ KCSR ಅಂತ ಒಂದು ಸಬ್ಜೆಕ್ಟ್ ಇಟ್ಟಾಗ ಅದನ್ನ ಸಪರೇಟ್ ಆಗಿ ಡೀಲ್ ಮಾಡಬಹುದು. These are also relating to the service benefits. They require to approach the administrative tribunal alone.
ಸರ್ ಗೊತ್ತಾಗಿದೆ ಸರ್, ಗೊತ್ತಾಯ್ತು ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಹಲೋ
ಇನ್ನೊಂದು ಯಾರು ಕೇಳ್ತಿದ್ದಾರೆ, ಕೇಳಿ ಸರ್. ಕೃಷ್ಣಪ್ಪ
ಸರ್, ನಮಸ್ಕಾರ ಸರ್. ನಮಸ್ಕಾರ ಸರ್, ನಾನು
ಹೇಳಿ
ವೇಣು ಅಂತ
ಹೇಳಿ ವೇಣು.
ಸರ್, ರೀಸೆಂಟ್ಲಿ ಒಂದು ಇನ್ಸಿಡೆಂಟ್ ನಲ್ಲಿ ನನ್ನ ಕ್ಲೈಂಟ್, ಶಿ ವಾಸ್ ಅ ರಿಟೈರ್ಡ್ ಹೆಡ್ ಮಿಸ್ಟ್ರೆಸ್ ಫ್ರಮ್ ಎಜುಕೇಶನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್. ಅವ್ರದ್ದು ಪೆನ್ಷನ್ ಮತ್ತೆ ಗ್ರಾಚ್ಯುಟಿ ಹೋಲ್ಡ್ ಮಾಡಿದ್ರು ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್, ಬಿಕಾಸ್ ಆಫ್ ಸಮ್ ಮಿಸ್ಅಪ್ರಾಪ್ರಿಯೇಷನ್ ಅನ್ನೋ ಒಂದು ರೀಸನ್ಗೋಸ್ಕರ. ಇದು AG ಆಫೀಸ್ಗೆ ಕೊಡದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಅದ್ರ ಪ್ರಕಾರ ನಾವು ಇದಕ್ ಹೋದ್ವಿ, ಯಾವ್ದು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರಿಬ್ಯುನಲ್ಗೆ. ಬಟ್ ಅಲ್ಲಿ ಆ ಜುರಿಸ್ಟಿಕ್ಷನ್ ಅಲ್ಲ ಬರಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೈಕೋರ್ಟ್ಗೆ ಹೋಗಿ ಅಂದಾಗ ಅಲ್ಲಿ ವಿಡ್ರಾ ಮಾಡಿ ತಿರ್ಗಾ ಹೈಕೋರ್ಟ್ಗೆ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕ್ಬೇಕಾಗ್ ಬಂತು. ಸೊ ಈ ತರ ಒಂದು ಪರಿಸ್ಥಿತಿನಲ್ಲಿ ಈವನ್ ಶೀಸ್
ಈ ಪರಿಸ್ಥಿತಿ ಯಾಕೆ ಬಂತು ಅಂತಂದ್ರೆ ವೆದರ್ ಅವರು ಗೌರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್, ಸಿವಿಲ್ ಸರ್ವೆಂಟ್ ಆರ್ ನಾಟ್ ಅಂತ.
she's a government school, I mean aided school,
Aided school
retired
did not
headmistress.
fall within the purview of administrative tribunal.
Okay, so ಆ ಒಂದು
Then tribunal is right in saying that.
okay,
Then High Court is right in entertaining.
okay sir. ಯಾಕಂದ್ರೆ ಅವ್ರಿಗೆ ಗೌರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯ್ ಅಂತ ನಾವು ಅಲ್ಲೋದ್ವಿ, ಆಮೇಲೆ ಅವ್ರು ಏಡೆಡ್ ಸ್ಕೂಲ್
Aided
ಆಗಿರೋದ್ರಿಂದ
school ಅವ್ರು ಬರೋದಿಲ್ಲ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಅವ್ರ ಗೌರ್ಮೆಂಟ್ ಸಂಬಳ ಏಡ್ ಮೂಲಕ ತಗೊಂಡ್ರು ಸಹ ಸರ್ಕಾರಿ ನೌಕರರು ಅಂತ ಆಗೋದಿಲ್ಲ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಮತ್ತೆ ಯಾರಿಗಾದ್ರೆ ಪ್ರಶ್ನೆಗಳಿದೆ ದಯವಿಟ್ಟು ಕೇಳಬಹುದು. ಯಾವುದೋ ಒಂದು ಇದು ಬರ್ತಿದೆ, ವೈಟ್ ಬೋರ್ಡ್. ಇಫ್ ಎನಿಬಡಿ ಇಸ್ ಹ್ಯಾವಿಂಗ್ ಸಮ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕ್ಯಾನ್ ಪ್ಲೀಸ್ ಆಸ್ಕ್. ಯಾರಾದ್ರೂ ಪ್ರಶ್ನೆಗಳಿದೆ ದಯವಿಟ್ಟು ಕೇಳಬಹುದು. ಒಬ್ರು ಒಂದು ಸಲಹೆಯನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್. ಏನಂತ ಹೇಳಿದ್ರೆ, ಒಂದು ಸಣ್ಣ ಹಂಬಲ್ ರಿಕ್ವೆಸ್ಟ್ ಟು ಟೇಕ್ ಅನದರ್ ಸೆಷನ್ ಅಂಡ್ ಇಂಪಾರ್ಟ್ ಬ್ಯಾಲೆನ್ಸ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೂಡ ಕೊಡಬೇಕಾಗಿ ಬರ್ತಿತ್ತು. ತಾವು ದಯವಿಟ್ಟು ಇನ್ನೊಂದು ಕ್ಲಾಸ್ ಕೂಡ ತಗೊಳ್ಬೇಕು ಅನ್ನೋ ಒಂದು ಮನವಿಯನ್ನು ಕೂಡ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸೊ ತಾವು ದಯವಿಟ್ಟು ಅದನ್ನ ಒಂದು
ಅಲ್ಲ, ಏನಕ್ಕೆ ಇನ್ನೊಂದು ಸೆಷನ್ ಇದೇ ಸಬ್ಜೆಕ್ಟ್
ಇದೇ ಸಬ್ಜೆಕ್ಟ್ ಮೇಲೆ
Sir,
ಅವ್ರಿಗೆ ದಿಸ್ ಇಸ್ ನಾಟ್
sir, excuse me, sir.
ಪ್ಲೀಸ್ ಹೇಳಿಮ್ಮ, ಯಾರು
Sir,
ಕೇಳಿ.
excuse me.
ಪ್ಲೀಸ್
ಹೇಳಿ ತಾಯಿ,
Hello.
ಹೇಳಿ ತಾಯಿ.
ಕೇಳ್ತಿದೆ.
ಸರ್, ಇದು ನನ್ನ ಒಂದು ಸ್ಮಾಲ್ ಕ್ವಶನ್ ಏನು ಅಂತಂದ್ರೆ, ಇತ್ತೀಚೆಗೆ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ಪೆನ್ಷನ್ಗೆ ಇಂತಿಷ್ಟು ವಯಸ್ಸು ಅಂತ ಮಾಡಿದಾರಲ್ಲ, ಅದು ಬೇರೆಯವ್ರಿಗೆ ತೊಂದರೆ ಆಗಲ್ವಾ? ಇವಾಗ ಎಲ್ಲರಿಗೂ ಈಕ್ವಲ್ ಆಗಿ ಇವಾಗ ಸರ್ಕಾರಿ
ಅದು
ನೌಕರರು ಅಂತ
ಈ
ಎಲ್ರು-
ಪರ್ವ್ಯೂ ಬರೋದಿಲ್ಲ, ಇವತ್ತಿನ ಕ್ಲಾಸ್ ಇದಕ್ಕೆ ಬರೋದಿಲ್ಲ.
ಹಾ.
ಇವತ್ತಿರುವಂತದ್ದು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರೈಬ್ಯುನಲ್, ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಅಂಡ್ ಪ್ರೊಸೀಜರ್ಸ್. ಅಂದ್ರೆ ಟ್ರೈಬ್ಯುನಲ್ ಯಾಕೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಯ್ತು, ಅಲ್ಲಿ ಯಾವ ತರ ತೀರ್ಮಾನ ಮಾಡ್ತಾರೆ, ಅದ್ರ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಪರ್ವ್ಯೂಗೆ ಯಾವ್ದು ಬರ್ತದೆ, ಯಾವ ತರ ತೀರ್ಮಾನ ಮಾಡ್ತಾರೆ ಅಂತ.
Okay, okay, thank you.
ಪೆನ್ಷನ್ ಕೇಳೋದು KCSR ಸಂಬಂಧಪಡುತ್ತೆ.
ಓಕೆ, ಓಕೆ.
Sir,
ಆದ್ರೂ ಹೇಳ್ಬೇಕು ಅಂತಂದ್ರೆ, ಏಜು ಅಂತ ಇಟ್ಕೊಂಡಿರೋದು ಎಲ್ಲಿದೆ? ಏಜು ಅಂತ ಏನು ಇಲ್ವಲ್ಲ. ಆದ್ರೆ ಇದು ನ್ಯೂ ಪೆನ್ಷನ್, ಓಲ್ಡ್ ಇದಕ್ಕೆ ಒಂದು ಕಟ್ ಆಫ್ ಡೇಟ್ ಇದೆ. ಆ ದಿವಸದಿಂದ ಹೊರಗೆ ಇದು ಬರೋದಿಲ್ಲ ಅಂತಂದು ನ್ಯೂ ಪೆನ್ಷನ್ ಸ್ಕೀಮ್ ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ ಅಲ್ವಾ?
ಅದೇ 25 years ಅವರು ಸರ್ವಿಸ್ ಮಾಡಿರ್ಲೇಬೇಕು ಅಂದ್ಬಿಟ್ಟು ಹೊಸದಾಗಿ ಮಾಡ್ತಾ ಇದಾರೆ. ಓಲ್ಡ್ ಪೆನ್ಷನ್ ಸ್ಕೀಮ್ ಅಲ್ಲಿ
ಅದನ್ನ
ನೀವು
ನಂತರ ನೋಡ್ಕೋಬಹುದಾಗ ಕ್ವಾಲಿಫೈಯಿಂಗ್ ಸರ್ವಿಸ್ ಅದನ್ನ
ಅಂದ್ರೆ qualifying-
ನಿಮಗಿರೋ ಈ ರೈಟ್ ಅನ್ನ ಅದನ್ನ ಕಿತ್ಕೊಳ್ಳಿಕ್ ಆಗಲ್ಲ. ಈಗ ನೀವು ಆಲ್ರೆಡಿ ಎಂಪ್ಲಾಯಿ ಆಗಿತ್ತು ಅಂತಂದ್ರೆ, ಈಗ 10 ವರ್ಷ 12 ವರ್ಷ ಆಗೇನಾದ್ರೂ ಇತ್ತು ಅಂತಂದ್ರೆ 25 ವರ್ಷ ಮಾಡಿ ಆ ರೈಟ್ ಅನ್ನ ಕಸಿದ್ಕೊಳ್ಳಿಕ್ ಆಗೋದಿಲ್ಲ.
ಆದ್ರೆ ಜಾಯಿನ್ ಮಾಡ್ಸ್ಕೊಂಡ್ಮೇಲೆ ಎಲ್ರಿಗೂ ಈಕ್ವಲ್ ಆಗಿ ಅವ್ರನ್ನ ಈಕ್ವಾಲಿಟಿಯಲ್ಲಿ ನೋಡ್ಬೇಕಲ್ಲ. ಒಬ್ಬರಿಗೆ 25 years
ಅದು ಬೇರೆ ಬಿಡಿ, ಅದನ್ನ ನಕಾರ ಕೇಸನ್ನ ಹಾಕೊಂಡು ಬೇಕಾದ್ರೆ ಆಮೇಲೆ ನೋಡ್ಬೋದು.
ಥ್ಯಾಂಕ್ ಯು.
sir, one ಪ್ರಶ್ನೆ. In case of dispute regarding commutation, can we approach High Court without coming to KSAT, sir?
You require to approach the KAT, sir.
So we have to approach KSAT only.
It is, it has to be dealt with reference to the KCSR ಅಲ್ವಾ?
ಹೌದು ಸ್ವಾಮಿ.
Through proper
KCSR ಅಂತಂದ್ರೆ ಅಲ್ಲಿಗೆ ಹೋಗುತ್ತಲ್ವಾ? ಈವನ್ ಏಡೆಡ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್ಗೂ KCSR ಅಪ್ಲಿಕಬಲ್ ಆಗುತ್ತೆ ಆ ತರ ಇಶ್ಯೂಗಳಾದ್ರೆ. ಆದ್ರೆ ಅವ್ರು ಸಿವಿಲ್ ಸರ್ವೆಂಟ್ಸ್ ಆಗೋಲ್ಲ. ಏನೇ ಗ್ರಿವೆನ್ಸ್ ಮೈನ್ಯೂಟ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಇಂದ ಹಿಡಿದು ಕೊನೆ ಸೆಟಲ್ಮೆಂಟ್ ಆಫ್ ಪೆನ್ಷನ್ಸ್ ಇದ್ರವರೆಗೂ ಎಲ್ಲದಕ್ಕೂ ನೀವು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರೈಬ್ಯುನಲ್ ಇರೋವರೆಗೂ ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಅಂತ.
ಈಗ ಸರ್, KSAT ಇಂಟ್ರಿಮ್ ರಿಲೀಫ್ ಕೊಟ್ಟಿದ್ದಾಗ್ಲೂ ಈ ಸಂಬಂಧಪಟ್ಟ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅದನ್ನ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡೋದಿಲ್ಲ 3 ತಿಂಗಳಾದ್ರು. ಅದ್ರ ಮೇಲೆ ಏನ್ ಕ್ರಮ ಸರ್?
Section 17 of the Administrative Tribunal Act, contempt.
ಸೊ ಅದು ಟ್ರಿಬ್ಯುನಲ್ ಸುವಮೋಟ ತಗೊಳತ್ತಾ ಅಥವಾ ಅಪ್ಲಿಕೆಂಟ್ ಅರ್ಜಿ ಹಾಕ್ಬೇಕಾ?
ನೀವು ಟ್ರೈಬ್ಯುನಲ್ ಇಫ್ ಇಟ್ ಇಸ್ ಮ್ಯಾಗ್ನಾನಿಮಸ್, ಇಫ್ ಇಟ್ ಇಸ್ ಬ್ರಾಟ್ ಅವರ ಗಮನಕ್ಕೆ ತಂದಾಗ ಸುವಮೋಟೋ ಬೇಕಾದ್ರೂ ತಗೋಬಹುದು. ಆದ್ರೆ ನಾರ್ಮಲ್ ಕೇಸ್ಗಳಲ್ಲಿ ಏನಿದೆ ಅಂತಂತಂದ್ರೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೇ ಹಾಕ್ತಾರೆ ಅಂತ.
ಸೊ ನಾವು ಅರ್ಜಿ ಹಾಕ್ಬೇಕು ಸ್ವಾಮಿ.
ಹಾಕ್ಬೇಕು. ಸೆಕ್ಷನ್ 17 ಆಫ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರೈಬ್ಯುನಲ್ ಆಕ್ಟ್.
ಧನ್ಯವಾದಗಳು ಸ್ವಾಮಿ.
ಸರ್ ನಮಸ್ಕಾರ ಸರ್. ಸರ್ ನಮಸ್ಕಾರ.
ನಮಸ್ಕಾರ ಸರ್.
ನನ್ನ ವಿನಂತಿ ಏನು ಅಂತ ಹೇಳಿದ್ರೆ ನಮ್ಗೆ ಇನ್ನಷ್ಟು ಇನ್ಫಾರ್ಮೇಟಿವ್ ಕ್ಲಾಸ್ ಯಾವ ರೀತಿ ಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ, ಒಂದು ನಮ್ಗೆಲ್ಲ ಕೂಡ ಈ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಗಳು ಸಾಮಾನ್ಯವಾಗಿ ರಾಜ್ಯದ ಬಹಳಷ್ಟು ಜನ ವಕೀಲರಿಗೆ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಗಳ ಅನುಭವಗಳು ಕಡಿಮೆ ಇರೋದ್ರಿಂದ ಹಾಗಾಗಿ ತಾವು ತಮ್ಮಿಂದ ಒಂದಿಷ್ಟು ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಗಳಿಗೆ ನಾವು ಅಥವಾ ಪಿಟಿಷನ್ ಅನ್ನ ಕಂಪ್ಲೇಂಟ್ ಪ್ರಿಪೇರ್ ಮಾಡುವಂತ ಬಗ್ಗೆ ಮತ್ತೆ ಅದಕ್ಕೆ ಬೇಕಾದಂತ ಏನು ಮಾಹಿತಿಯನ್ನ ಕಲೆಕ್ಟ್ ಮಾಡುವಂತದ್ದು ಹೇಗೆ, ಮತ್ತೆ ನಾವು ಅಫಿಯರ್ ಆದಾಗ ಅಲ್ಲಿಯ ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಯಾವ ರೀತಿ ನಡೀತದೆ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಒಂದಿಷ್ಟು, ಮತ್ತೆ ಆಗ್ಲೇ ಯಾರೋ ಒಬ್ರು ಮಹಿಳಾ ವಕೀಲರು ಪ್ರಶ್ನೆಯನ್ನ ಕೇಳ್ತಾ ಇದ್ರು. ಇನ್ನೊಬ್ರು ಯಾರೋ ಅವರು ಸ್ಕೂಲ್ ಹೆಡ್ ಮಾಸ್ಟರ್ ಆಗಿದ್ರು, ಎಡೆಡ್ ಸ್ಕೂಲ್ ಅಲ್ಲಿ ಇದ್ರು, ನಾವು KIT ಹೋದ್ವಿ, ಅಲ್ಲಿಂದ ಪುನಃ ಅಲ್ಲಿ ಎಂಟರ್ಟೈನ್ ಆಗ್ಲಿಲ್ಲ, ಸೊ ವಾಪಸ್ ಹೈಕೋರ್ಟ್ಗೆ ಹೋದ್ವಿ ಅಂತ. ಹಾಗಾಗಿ ಒಂದಿಷ್ಟು ಕ್ಲಾರಿಟಿ, ಯಾವ್ಯಾವ ಸರ್ಕಾರಿ ನೌಕರರು ಅಂತ ಅನ್ಸ್ಕೊಂಡೆ ಯಾವ ವಿಭಾಗದವ್ರು ಬರ್ತಾರೆ, ಯಾವ ವಿಭಾಗದವ್ರು ಬರೋದಿಲ್ಲ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಇನ್ನೊಂದಿಷ್ಟು ಇನ್ಫಾರ್ಮೇಟಿವ್ ಆಗಿ ಮತ್ತೊಂದು ಉಪನ್ಯಾಸ ನೀಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಆದ್ರೆ ಬಹಳ ಅನುಕೂಲ.
ಹೇಳ್ಬೋದು, ಡೀಟೇಲ್ ಆಗಿ ಲಿಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಹೇಳ್ಬೋದು, ಇವ್ರು ಬರುತ್ತೆ ಈಗ ಬರುತ್ತೆ. ಆಸ್ ಫಾರ್ ಆಸ್ ಕರ್ನಾಟಕ ಇಸ್ ಕನ್ಸರ್ನ್ ಇದುವರೆಗೂ ಎಷ್ಟು ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ಬೋದು. ಮೋಸ್ಟ್ ಪ್ರಾಬಬ್ಲಿ ಅವ್ರಿಗೆ ಹೇಳಿದ್ದ ಕೃಷ್ಣಪ್ಪನವ್ರು ಹೇಳಿದ ಕೇಸ್ ಇದರಲ್ಲಿ ನಾನೇ ಒಂದಷ್ಟು ದಿವಸ ಜುಡಿಷಿಯಲ್ ಮೆಂಬರ್ ಆಗಿದ್ದಾಗ ಏಡೆಡ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಕೇಸ್ಗಳು ಸುಮಾರು 4-5 ಕೇಸು ಬರೋದಿಲ್ಲಪ್ಪ, ನೀವು ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡು ಅಲ್ಲಿಗೆ ಹೋಗಿ, ಇಲ್ಲ ನಾನೇ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ಹೈಕೋರ್ಟ್ ತಗೊಂಡೋಗಿ ಅಂತ ಹೇಳಿದೀನಿ. ಒಂದು ದಿನ ಎಕ್ಸ್ಟ್ರಾ ಇಟ್ಕೊಂಡ್ರೆ ಅವರಿಗೆ ಒಂದು ದಿನ ಎಕ್ಸ್ಟ್ರಾ ನಾವು ತಪ್ಪು ಮಾಡ್ದಂಗೆ ಆಗುತ್ತೆ. ಹಾಗೆ
ಇನ್ನೊಂದು ಉಪನ್ಯಾಸವನ್ನ ಆ ವಿಷಯದ ಮೇಲೆ ಬೆಳಕು ಚೆಲುವ ನಿಟ್ಟಿನಲ್ಲಿ ಕೊಟ್ರೆ ಬಹಳ ಅನುಕೂಲ ಅನ್ನೋದು.
ಆಕ್ಚುಯಲ್ ಆಗಿ ಕ್ಲಾರಿಟಿ ಏನು, ಯಾರ್ಯಾರು ಅಪ್ರೋಚ್ ಮಾಡಬಹುದು ಏನ್ ಕತೆ ಅಂತ ನೋಡಿ. ಪ್ಲೀಸ್ ಸಮಯ ಸಿಕ್ಕಿದಾಗ ಅದನ್ನ ನೀವು ಹೇಳಿದಾಗ ಹೇಳಿದ್ ಮಾಡೋಣ. ಅದ್ರ ಜೊತೆಗೆ ಇನ್ಯಾವುದನ್ನ ಲಿಂಕ್ ಮಾಡ್ಕೊಂಡು ಮಾಡ್ಬೋದು.
ಬೇರೆ ಯಾವ್ದು ಪ್ರಶ್ನೆಗಳು ಇಲ್ಲ ಅನ್ಬಿಟ್ಟು ಅನಿಸ್ತಾ ಇದೆ ಸರ್.
ಅಲ್ಲ,
ಅದರಿಂದ
ಎಜುಕೇಶನ್ ಟ್ರಿಬ್ಯುನಲ್ ಬರ್ತಾವಲ್ಲ ಅವೆಲ್ಲ ಕೇಸಸ್
ಎಜುಕೇಶನ್ ಟ್ರೈಬ್ಯುನಲ್ ಇದಕ್ಕೆ ಇದನ್ನ ಬರೋದಿಲ್ಲ. ಯು ರಿಕ್ವೈರ್ಡ್ ಟು ಅಪ್ರೋಚ್ ಅಂಡರ್ ಎಜುಕೇಶನ್ ಆಕ್ಟ್ ಬಿಫೋರ್ ದಿ ಅಂಡರ್ 130, 31 and 33
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್.
ಅದರಲ್ಲಿ ಬರುವಂತದ್ದು ಓನ್ಲಿ ಡಿಸ್ಮಿಸಲ್, discharge for misconduct.
Okay.
94, section 94 of the Education Act.
EAT.
ಮೊದಲು ಎಲ್ಲ ಇತ್ತು ಸರ್. 1978 ರೂಲ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲಾ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿಗೆ ಬರ್ತಾ ಇತ್ತು.
EAT ಬರ್ತಾ ಇತ್ತು.
ಈಗ ಎಲ್ಲ ತೆಗೆದುಬಿಟ್ರಲ್ಲ, ಬರೀ 94 ಹಾಕಿಬಿಟ್ಟು ಕರೆಕ್ಟಾಗಿ ಮಾಡ್ಬಿಟ್ರು. ಡಿಸ್ಚಾರ್ಜ್, ಡಿಸ್ಮಿಸಲ್, ಟರ್ಮಿನೇಷನ್ ಫಾರ್ ಮಿಸ್ಕಾಂಡಕ್ಟ್ ಓನ್ಲಿ.
ಇವಾಗ ಬೇರೆ ಯಾವ್ದು ಪ್ರಶ್ನೆಗಳಿಲ್ಲ ಅನ್ಸುತ್ತದೆ. ಅದರಿಂದ ಐ ರಿಕ್ವೆಸ್ಟ್ ನಮ್ಮ ಸಂಘದ ಅಧ್ಯಕ್ಷರಾಗಿರುವಂತಹ ಶ್ರೀ ಹರೀಂದರ್ ಅವರು ಸರ್ ಹೇಳಿದ್ರೆ
ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಕ್ಲಾಸ್ ನೀವು ಕನ್ಸಿಡರ್ ಮಾಡುವಾಗ ದಯವಿಟ್ಟು ನಮ್ಗೆ ಈ KCSR ಮತ್ತೆ ನ್ಯೂ ಪೆನ್ಷನ್ ಸ್ಕೀಮು, ಓಲ್ಡ್ ಪೆನ್ಷನ್ ಸ್ಕೀಮು, ಇದು 3 ಟಾಪಿಕ್ ಮೇಲೂ ಅಲಾಂಗ್ ವಿತ್ ಈಗ ಬೇರೆ ಇನ್ನೊಬ್ರು ಒಂದು ರಿಕ್ವೆಸ್ಟ್
ದೊಡ್ಡದಾಗ್ಬಿಡುತ್ತೆ ಅಂತ ಕಾಣುತ್ತೆ.
ಇಲ್ಲ ಸರ್,
ಇದು ಇನ್ನೊಂದೇನು ಅಂತಂದ್ರೆ ಸ್ಪ್ಲಿಟ್ ಮಾಡಿಕೊಂಡು ಸ್ವಲ್ಪ ಎಲಾಬರೇಟ್ ಆಗಿ ಇದು ಮಾಡೋ ರೀತಿಯಲ್ಲಿ ಸ್ಪ್ಲಿಟ್ ಬೇಕಾದ್ರೆ ಮಾಡೋಣ.
ಖಂಡಿತ ಹಾಗೆ
ಹೌದು. ಒಂದಿನ KCSR ಮತ್ತೊಂದಿನ ನ್ಯೂ ಪೆನ್ಷನ್ ಸ್ಕೀಮು ಮತ್ತೆ ಓಲ್ಡ್ ಪೆನ್ಷನ್ ಸ್ಕೀಮು ಎರಡನ್ನೂ ಸಪರೇಟ್ ಮಾಡ್ಬೋದು ಅನ್ಸುತ್ತೆ ನೋಡಿ ಸರ್.
ಖಂಡಿತ ಮಾಡೋಣ ಸರ್, ಖಂಡಿತ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್ ಸರ್. ಇಟ್ ವಾಸ್ ವೆರಿ ಇನ್ಫಾರ್ಮೇಟಿವ್ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಥ್ಯಾಂಕ್ಸ್ a lot.
Thanks for all your efforts sir.
Thank you sir. Most welcome sir. It's all because of your all cooperations.
I think our corporation sir, it is all work done by you sir. Thank you sir.
ನಮ್ಮ ಸಂಘದ ಅಧ್ಯಕ್ಷರಾಗಿರುವಂತಹ ಶ್ರೀ ಹರೀಂದರ್ ಅವರವರು ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮದ ಸಮರ್ಪಣೆ ಅಥವಾ ವಂದನಾರ್ಪಣೆಯನ್ನು ಮಾಡಬೇಕು ಅಂತ ಕೋರಿಕೊಳ್ಳುತ್ತಿದ್ದೇನೆ. ಶ್ರೀ ಹರೀಂದರ್ ಅವರು ಸಂಘದ ಅಧ್ಯಕ್ಷರಾಗಿರುವರು ದಯವಿಟ್ಟು ತಾವು ತಮ್ಮ ವಿಡಿಯೋವನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿಕೊಂಡು ವಂದನಾರ್ಪಣೆ ಮಾಡಬೇಕು ಅಂತ ಕೇಳ್ಕೊಳ್ತೀನಿ. ಸರ್ ಇದ್ರ ಸರ್?
ಬಂದೆ
ಬನ್ನಿ ಸರ್.
ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಖಂಡಿತ ಸರ್.
ಗೌರವಾನ್ವಿತ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರಿಬ್ಯುನಲ್ ನ ಮಾಜಿ ಸದಸ್ಯರಾದಂತ ಟಿ ನಾರಾಯಣಸ್ವಾಮಿ ಅವರಿಗೆ ಇವತ್ತು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಟ್ರಿಬ್ಯುನಲ್ ನ ಪ್ರೊಸೀಜರಲ್ ಆಸ್ಪೆಕ್ಟ್ ಬಗ್ಗೆ ಸುದೀರ್ಘವಾದಂತ ಒಂದು ಕ್ಲಾಸ್ ಅನ್ನ ಕೊಟ್ಟಿದ್ದಕ್ಕಾಗಿ ಅವರಿಗೆ ಧನ್ಯವಾದಗಳನ್ನ ಅರ್ಪಿಸ್ತೇನೆ. ಇದೇ ಸಂದರ್ಭದಲ್ಲಿ ಈ ದಿನ ಯಾರೆಲ್ಲ ಕ್ಲಾಸ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ, ಈ ಕ್ಲಾಸಿನ ಉಪಯೋಗವನ್ನು ಪಡ್ತಾ ಇರ್ತಕ್ಕಂಥ ವಕೀಲರು ಮತ್ತು ಪರೀಕ್ಷಾರ್ಥಿಗಳು ಎಲ್ಲರೂ ಕೂಡ ಈ ಸಂದರ್ಭದಲ್ಲಿ ಧನ್ಯವಾದಗಳನ್ನ ಅರ್ಪಿಸ್ತೇನೆ. ಮತ್ತು ನಾನು ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಅನ್ನ ಎಲ್ಲ ಇಲ್ಲಿ ಯಾರು ಈ ಉಪಯೋಗವನ್ನ ಆನ್ಲೈನ್ ಕ್ಲಾಸಸ್ ನ ಉಪಯೋಗವನ್ನ ಅಖಿಲ ಭಾರತ ವಕೀಲರ ಒಕ್ಕೂಟದ ಮುಖಾಂತರ ಪಡಿತಾ ಇದ್ದಾರೆ, ನೀವೆಲ್ಲರೂ ಕೂಡ ಅಖಿಲ ಭಾರತ ವಕೀಲರ ಒಕ್ಕೂಟದ ಸದಸ್ಯರಾಗಬೇಕು ಮತ್ತು ಅಖಿಲ ಭಾರತ ವಕೀಲರ ಒಕ್ಕೂಟದ ಆಶಯಗಳೇನಿದಾವೆ, ಅವ್ರೇನೆಲ್ಲ ಕಾರ್ಯಕ್ರಮಗಳನ್ನು ಮಾಡ್ತಾರೆ ಅಖಿಲ ಭಾರತ ವಕೀಲರ ಒಕ್ಕೂಟ, ಈ ವಿಚಾರಗಳಲ್ಲೂ ಕೂಡ ತಾವು ಭಾಗಿಗಳಾದರೆ ನಮಗೆ ಇನ್ನೂ ಹೆಚ್ಚಿನ ಸ್ಟ್ರೆಂಗ್ತನ್ ಆಗ್ತದೆ ಸಂಘಟನೆ ಇಡೀ ರಾಜ್ಯದಲ್ಲಿ ಅಂತಕ್ಕಂಥ ಮಾತನ್ನ ಇವತ್ತಿನ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಎಲ್ಲ ಜನರಲ್ಲೂ ಕೂಡ, ಎಲ್ಲರ ವಕೀಲರಲ್ಲೂ ಕೂಡ, ಎಲ್ಲ ಪರೀಕ್ಷಾರ್ಥಿಗಳಲ್ಲೂ ಕೂಡ ನಾನು ತಮ್ಮಲ್ಲಿ ಬೇಡ್ಕೊಳ್ತೇನೆ. ಈಗ ಅನೇಕ ಹೋರಾಟಗಳನ್ನ ರೂಪಿಸ್ತಾ ಇರ್ತೀವಿ. ಈಗ ಜೂನ್ 13ಕ್ಕೆ ನಾವು ವಕೀಲರಿಗಿರ್ತಕ್ಕಂಥ ಅನೇಕ ಸಮಸ್ಯೆಗಳು ಏನಿದಾವೆ, ಇವತ್ತು ಕಾಡ್ತಾ ಇರ್ತಕ್ಕಂಥ ಸಮಸ್ಯೆಗಳು ಅನೇಕವಿದಾವೆ. ಆ ಎಲ್ಲ ವಿಚಾರಗಳನ್ನ ಈಗಾಗಲೇ ನಾವು ಪಾಂಪ್ಲೆಟಿನ ಮುಖಾಂತರ ತಮಗೆ ತಲುಪಿಸ್ತಾ ಇದ್ದೀವಿ. ಆ ವಿಚಾರಗಳಲ್ಲೂ ಕೂಡ ತಾವು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಬೇಕು. ಅಖಿಲ ಭಾರತ ವಕೀಲರ ಒಕ್ಕೂಟವನ್ನ ಬಲಿಷ್ಠಗೊಳಿಸ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ತಾವೆಲ್ಲ ಏನಿದ್ದೀರಿ, ತಮ್ಮೆಲ್ಲರ ಬೆಂಬಲ ಅನಿವಾರ್ಯವಾಗಿ ನಮಗ್ ಬೇಕಾಗಿದೆ. ಆ ದೃಷ್ಟಿಯಿಂದ ಕೂಡ ನಾವು ಮಾಡ್ತಕ್ಕಂಥ ಇತರೆ ಕಾರ್ಯಕ್ರಮಗಳಲ್ಲೂ ಕೇವಲ ಆನ್ಲೈನ್ ಕ್ಲಾಸಸ್ ಅನ್ನ ಮಾತ್ರ ಉಪಯೋಗಿಸ್ಕೊಳ್ಳೋದಲ್ಲ, ಬೇರೆ ರೀತಿಯ ಕಾರ್ಯಕ್ರಮಗಳಲ್ಲೂ ಕೂಡ ನೀವು ಭಾಗಿಗಳಾಗ್ಬೇಕು, ಸದಸ್ಯರಾಗ್ಬೇಕು. ನಾವೇನೆಲ್ಲ ಹೋರಾಟಗಳು ರೂಪಿಸ್ತೀವಿ ಅದರಲ್ಲೂ ಕೂಡ ತಮ್ಮ ಪಾತ್ರ ಇದ್ರೆ ನಮಗೆ ಈ ಒಂದು ಕ್ಲಾಸಸ್ ಅನ್ನ ಮಾಡುತ್ತಾ ಇರೋದಕ್ಕೆ ನಮ್ಗೆ ಸ್ಫೂರ್ತಿ ಸಿಗ್ತದೆ ಅಂತಕ್ಕಂಥ ಮಾತನ್ನ ಹೇಳ್ತಾ, ಇನ್ನು ಮುಂದೆ ಆಗ್ತಕ್ಕಂಥ ಎಲ್ಲ ಅಖಿಲ ಭಾರತ ವಕೀಲರ ಒಕ್ಕೂಟದ ಕಾರ್ಯಕ್ರಮಗಳಲ್ಲೂ ಭಾಗವಹಿಸ್ತೀರಿ ಅಂತಕ್ಕಂಥ ಆಶಯದೊಂದಿಗೆ ತಮ್ಮೆಲ್ಲರಿಗೂ ವಂದಿಸ್ತಾ, ಮತ್ತೊಂದ್ಸಲ ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ರೂಪಿಸಿದಂತ ಪೇಶ್ವಾವರ್ಗೂ, ನಮ್ಮ ಅಖಿಲ ಭಾರತ ವಕೀಲರ ಒಕ್ಕೂಟದ ಆನ್ಲೈನ್ ಕ್ಲಾಸಿನ ಸದಸ್ಯರಿಗೂ ಮತ್ತು ಅಖಿಲ ಭಾರತ ವಕೀಲರ ಒಕ್ಕೂಟದ ಎಲ್ಲಾ ಪದಾಧಿಕಾರಿಗಳಿಗೂ ವಂದಿಸಿ, ಮತ್ತೊಂದ್ಸಲ ಬಹಳ ಸುದೀರ್ಘವಾದಂತ ಕ್ಲಾಸ್ ಅನ್ನು ಕೊಟ್ಟಂತ ನಮ್ಮ ಟಿ ನಾರಾಯಣಸ್ವಾಮಿ ಅವರಿಗೆ ಮತ್ತೊಂದ್ಸಲ ಧನ್ಯವಾದಗಳನ್ನ ಹೇಳ್ತಾ ಈ ಧನ್ಯವಾದಗಳನ್ನ ಹೇಳ್ತೀನಿ ಅಂತಕ್ಕಂಥ ಮಾತನ್ನು
ವೆರಿ ಕೈಂಡ್ ಸರ್. ಎಲ್ಲರ ಒಂದು ಗಮನಕ್ಕೆ ಇವತ್ತು ಯಾವ್ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಗಳನ್ನ ಕೋಟ್ ಮಾಡಿದವರೋ ಎಲ್ಲ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ. ಎಲ್ಲ ಕನ್ಸರ್ನ್ ಆನ್ಲೈನ್ ಗ್ರೂಪ್ ಗಳಿಗೆ ನಾವು ಖಂಡಿತ ಅಪ್ಲೋಡ್ ಮಾಡ್ತೀವಿ. ಮತ್ತೆ ಇವತ್ತು ನಡೆದಿರುವಂತ ಕಾರ್ಯಕ್ರಮ ಕೂಡ ನಮ್ಮ ಐಲುವಿನ ಸೋಷಿಯಲ್ ಮೀಡಿಯಾ ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ ಅದು ಲೈವ್ರರಿ ಆಗಿದೆ, ಅದು ಕೂಡ ಅಪ್ಲೋಡ್ ಆಗಿದೆ. ದಯವಿಟ್ಟು ಅದನ್ನು ವೀಕ್ಷಣೆ ಮಾಡಬಹುದು. ಮತ್ತೆ ಏನೇ ಆದ್ರೂ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಬೇಕು, ದಯವಿಟ್ಟು ನಮ್ಮ ಆನ್ಲೈನ್ ಗ್ರೂಪ್ ಗಳಲ್ಲಿ ತಾವು ಕೇಳಬಹುದು. ಅದಕ್ಕೆ ಖಂಡಿತ ನಾವು ಸೂಕ್ತವಾದ ಮಾಹಿತಿಗಳನ್ನ, ಕ್ಲಾರಿಫಿಕೇಶನ್ ಉಪನ್ಯಾಸಕರ ಅವರ ಗಮನಕ್ಕೆ ತಂದು ಅವ್ರು ಕೊಡುವಂತ ಆನ್ಸರ್ ಗಳಿಗೆ ನೀವು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಧನ್ಯವಾದಗಳು ಸರ್. ತಮ್ಮ ಅನುಮತಿಯಿಂದ ಸಭೆಯನ್ನು ಮುಕ್ತಾಯ ಮಾಡಬಹುದು ಅನ್ಸುತ್ತೆ.
ಬಹಳ ವರ್ಷಗಳ ನಂತರ ಒಂದು ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟದಕ್ಕೋಸ್ಕರ ತಮ್ಮೆಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳು.
ವೆರಿ ಕೈಂಡ್ ಆಫ್ ಯು ಸರ್. ಥ್ಯಾಂಕ್ ಯು. ಥ್ಯಾಂಕ್ಸ್ ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳು, ವಂದನೆಗಳು.